Sit down. We want to get started.
And I picked up a cold in Berlin, and I have just been so sick that.
This is our final panel, and we have 4 panelists, so we are going to try to do a better job, that's me, on keeping time. I feel like it's rude to tell people to be quiet, but we're gonna do that anyway. The topic is related to what's gone on so far, but there's a slight, it's also slightly different. We're going to talk about genomic data and scientific data in general, publication, access, and secrecy. The moderator is Elizabeth Quiche, whom many of you have heard from last night's Venter lecture introducing Dr. Venter. Elizabeth is the founding director of the Buchanan Institute for Ethics here at Duke and an associate professor of the practice of political science and philosophy. She specializes in moral and political philosophy and has published articles, essays, and book chapters on rights and justice, moral education, and feminist theory. Elizabeth is on the steering committee of the Center for Genome Ethics, Law, and Policy. She was the acting director when it was a gleam in people's eye, and she's helped to organize a number of events focusing on genomics, including a public forum entitled Something Old, Something New, Does Genomics Pose New Ethical Questions? We always come to Elizabeth for titles for things, because she always has a snappy title. She's a graduate of Davidson College. She received a B.Phil and a D.Phil in philosophy from Oxford University. She was a Rhodes Scholar, and she has held fellowships at the Harvard Program in Ethics in the Professions and at the National Humanities Center. Elizabeth.
Gosh, thank you. Thank you, and we're in for a real treat. This is a wonderful panel, and I do hate being draconian with them, but we want to make sure that we will have time for Q&A and interaction at the end. But our first speaker is going to be Peter Newmark, who has a BA and PhD in biochemistry from Oxford University. He joined the journal Nature as biology editor in 1974 and left as deputy editor in 1990 to join the Current Science Group. There he managed the Current Opinion review journals and founded and edited the journal Current Biology. In 1997, he moved with these journals to Elsevier Science and became, which I probably mispronounced, and became responsible also for the Trends review journals. In 2000, he returned to the Current Science Group as biology editorial director for BioMed Centeral, which is a pioneering open access publisher. Peter Newmark.
Thank you. Lauren said this session would change a little bit from previous ones. As I'm starting it, it's actually going to change quite a lot, but I imagine it will drift back towards the central theme of this symposium. I want to thank the Center for Genome Ethics, Law and Policy for inviting me here, not only because I'm the only overseas speaker in at this meeting, but I also have absolutely no expertise in ethics, law, or policy. So you might wonder why I'm here. I'm also not a scholar. A number of people have been able to claim that before me. But I am responsible and have for many years been involved in the publishing of scholarly biomedical journals, including genomics journals most recently. And as journals, to an extent, control the publication of genomics papers, they have some limited, it is pretty limited influence on whether papers appear, when they do, and what conditions are attached to the publication of papers in terms of the data that's associated with the paper itself. As those of you, I'm sure it was all of you, heard Craig Venter last night, it is evident that at least in some areas of the commercial sector of producing genomic data, people do want to publish. Look at the number of covers of Science he showed, one after another. They want to publish papers, and they have to live with the rules that go with publishing of papers that have grown up over the years, or try and change them if they can. So I'm here as a publisher with a perspective on the conventions and the rules and the problems that have arisen with publishing biomedical science and with the associated access to the data that's behind the papers that are published, the materials that are involved in the research, and the content of the papers themselves, which is where I will, at the end of this, at the end of what I've got to say, come on to open access publishing. First thing I want to say, really, though, is that fundamentally, from a publisher's perspective, the conventions and the rules and all the problems are not particularly new. They've mostly are more to do with pre-genomics than to do with the genomic era. But there are some differences that have been brought about by genomics. The first, I suppose, is the one that we heard quite a bit about yesterday, and that is genomics, human genomics, has associated with it the problems of the arguments about common heritage and whose genome is it anyway. So it becomes rather more emotive. This was referred to yesterday as the people at the bottom of the bus. I rather feel that they're at the top of the bus, which is open at the top, and they're waving banners and have balloons, and it's the others who are at the bottom of the bus. But there we are. Whichever end it is, whichever top or bottom, there is an element of that. Secondly, of course, as everybody knows, human genomics has the potential for having great effects on medical advances, and that also brings a different perspective. If you're talking about genomics of the frog, it's rather different. And the third thing, very important, that makes life a little bit different now from perspective even of a publisher, is that genomics brings bucketfuls of data, bucketfuls being the old imperial measure, which is now teraflops, I think Craig going to say. But there are bucketfuls. They do need a computational approach. It's the only way one can deal with this data. This has brought forward the new discipline of bioinformatics, although it used to be computational biology, it's now bioinformatics. It's a sexier word, but it is a real change. And for the bioinformatics community, access to data is what they need. It's the lifeblood of their existence. And so they form a fairly vocal lobby when there is any question of not having access to the data that they need in order to be as productive as they can. Nevertheless, as I said, the issues that are evident to editors, publishers of journals aren't all that different. So let me just tell you, because you won't all know, the kind of conventions that have been built up over the years around publishing of original biomedical research in journals. There's one which does impinge on ethics, but really isn't related to this meeting, which is that journals do almost without exception, I think, say that if you're going to publish work that involves animal experimentation or humans, that research has to abide by the ethical rules and codes that control research in the country of origin. There is something which says, long been the case, that if you are going to publish a research paper that describes a method, the method must be described in enough detail that somebody else can reproduce it. This is because science doesn't progress in isolation. It always builds on previous science, and you can't build on it unless you can reproduce it and do it. You can't know if it's right unless you can reproduce it either. There is also a convention about the availability of materials that are described in scientific papers. So if you, in the course of your research, have made a new reagent, which is how you've managed to do your research, when you publish the paper, that reagent should be available to anybody who asks for it. You have an obligation to provide it. If you, in the course of your research, make, let's say, a new mutant mouse, you have to provide that mutant mouse to anyone who provides it after you have published the description of it. That's the convention. This is all about speedy progress in science. If you want the whole enterprise to move forward as quickly as possible, you should be able to use the materials or reagents or animals that others have produced. And most relevant to this symposium and the most recent convention that has arisen is the one about deposition of data. Papers, after all, scientific papers these days are very often just a discussion of the data. The data aren't included in the paper. And so the convention has arisen, first of all, in the world of protein structures, more recently in the world of gene sequencing and genomic sequencing, that when you publish a paper, you deposit the raw data that's behind the paper in a publicly accessible database. And you do so at the time of publication. This is partly so that there is quality control, so that people can actually look at the data themselves and see whether your interpretation of it is the one that is right, or they might have a different interpretation. Because, as I say, the papers are merely a description and interpretation of that data. It also helps with progress, because you don't have to do it yourself. It's there. You can build on it. As a result of that, there are some big publicly funded databases. There's one for protein structures called the Protein Database, and there's one for gene sequences, which is in the United States is called GeneBank, but there are also Japanese and European nodes. Now, these conventions were all essentially not devised by the journals. They were devised by the people within the scientific community, usually an activist group who got together, thought this was the way forward, and tried to make it happen. Sometimes it's been hard, sometimes it's been easy. In the end, what happens is that these conventions are imposed upon the scientists by their funding bodies if they get public funds. Of course, in the commercial sector, there's no imposition in that sense. And they're imposed on scientists by the journals, who are sometimes reluctantly, but are usually persuaded to say, okay, we'll make it a rule of publication that these things happen. As I say, journals are sometimes reluctant. I mean, they're not very keen and certainly not very effective at policing these policies, and they're certainly pretty useless at imposing penalties on people who transgress them. And believe me, there are a lot of transgressions. There was a survey recently coming out of I think it's called the Institute for Health Policy at Massachusetts General Hospital, which surveyed 3,000 US geneticists and asking them to what extent these conventions are held to. They had about 1,200 responses, and about half of those people said that within the last 3 years they had been denied either access to something they wanted, some information, some data or some materials. And 12% of the people who were asked actually owned up to being guilty of that. And I think something like 3/4 of the people who were surveyed said that this denial had impeded progress. So it is an issue, a real one. Now, where do the problems arise, really? Well, they don't arise very much in this convention that you are meant always to describe your method in a lot of detail. I mean, clearly, there are omissions there. You forget to say, if you forget the step in which you simmer gently for 3 hours and add a touch of tarragon, you don't finish up with quite the meal that you should. But that's usually not deliberate. There are, as that survey showed, frequent problems with the convention that the scientist who's published the work should subsequently provide reagents or materials to others. And this happens widely in the academic world as well as in the commercial sector. I remember long ago when I first joined Nature hearing a story of someone who, having seen a very interesting paper published describing a new virus, an RNA virus, wrote to the people saying, can I have a sample of it, and got no reply, and wrote 2 or 3 times and got no reply. Was getting nowhere with this, and so in the end had the bright idea of taking one of the letters that he eventually got, which said, I'm sorry, I'd like to give it to you, but I can't at the moment, but I will. Taking this letter, and this was pre-email, so it was real paper, and actually culturing the letter and getting the virus which had contaminated the letter itself. I'm never quite sure if that's true, but I have heard this story. Now, of course, we're talking mostly here about human genomics, but in the study of humans, you can go right to the other end of the spectrum and find the same kind of problems. There was a report a few weeks ago in Science about the problems that bedevil those who are studying fossils of early human ancestors. When you find a fossil, and it's quite hard to find these things, when you find one, usually what happens is there's a very brief description of it, an early one, and then 2 or 3 years later there's a full description. Now, competitors say, well, once there's a brief description, we should be able to get our hands on this fossil and look at it ourselves and interpret it. But in fact, there are very big difficulties in that, because the people doing it say, no, we want to hang on to it till we have our full description. And they say, it's very hard to find the fossil. We went through fire and water and in deserts and avoiding smart bombs which mistook Ethiopia for Iraq and all those things in order to find the fossils, and we don't want to let go of them too soon. There are also problems with materials in particular, because imagine you're a scientist, you've made this new antibody, it was hard to make, it requires lots of work, and then you publish a paper and everybody asks you for samples of it. Now, if you're going to provide the samples, you've probably got to devote the next few months to making the thing. And that's not reasonable, so people resist this. There are a couple of solutions to that. One is the granting body, and NIH I'm not sure if they're doing this, they certainly talked about it, are giving specific money so people can make reagents that are requested. The other is that you give it to a company, so anybody can have it, they just have to pay for it, but the company develops it. But in practical terms, it's very hard to follow that convention. There are certainly evolving problems with data deposition and access, and plenty of reasons for that. Obviously, one of the reasons why scientists can be reluctant to follow the rule that you give away what you've discovered at the point of publication is that you want to you don't want to let your competitors in too quickly. You've worked hard to do this. You want a head start, and you don't really see why, upon publication, you should let others take over. Particularly true of small labs who make an important discovery. If they have to give everything away immediately to very large enterprises, they'll be overtaken and left in the shadow, and that's not quite what they want the world to be. Obviously, if data is coming from the commercial sector, there are but not only the commercial sector, as we heard earlier this morning, also from the academic sector, particularly where the technology transfer people have been involved, there are other issues here. If, for example, your business is to sell access to the data, you clearly don't want to have to give it away when you publish it. That's not a very common circumstance, but it is within genomics, can be the case. Also, if you are bound to put your data into a publicly accessible open database, you have much less knowledge of who is using it, and therefore, if you have IP rights, you have much less ability to control them. Because anybody can go and pick up your data, and you don't know that they're doing it. There is one other issue which is really not to do with journals, but is to do with genomic data that has arisen and is a very live issue, and that arises out of the community deciding that it would be the best interests of science were data that is coming off the production line to be put into openly accessible databases before publication. It goes in at the time. Publication will happen at a certain stage. Maybe it's complete genome, or it may just be a part of it, whatever you're doing, but the data is there earlier. Now this is well and fine and does help progress things. The trouble is it's open to and has been abused in the sense that people can go in to the database with your partially completed genomic sequence. They can look at this sequence, they can use it, and they can publish papers based on it before the person who's generating the original data has had a chance to do so. There have been some quite notable disputes on this, and I think rules are emerging to say that you can't touch it without the permission of the other person or not for a certain time, but that has not yet really settled down. Now, there are clearly issues when a company wants to publish a paper. The journal says this means you deposit the data in an open public database, and the company wants to bend the rules. There have been some notable cases of this recently, particularly the Solera publication of the first draft of the human genome sequence in Science, well-publicized case. It's something which Dan Drell is going to, it's probably the starting point for his talk. So I won't say too much about it, other than the fact that as an open access publisher, I am clearly much in favor of open access to data as well. It's ironic, really, that there is a lot of fuss about open access to data, big push that data should be there and available for anyone to look at with no constraints. But it's not nearly so much about the papers that actually interpret the data. Data themselves, I mean, nobody can understand. It's only the interpretation that counts. It's also ironic that this survey I told you about of geneticists, I actually haven't been able to look at the paper. I've only been able to see secondary accounts of it because I don't have a subscription to the journal, and so I'm constrained from looking at this interesting paper. So genomic data does tend to be freely available, and but papers very often not, and yet they're mostly publicly funded. They're given to publishers. The papers are given to publishers for nothing. Copyrights given to the publisher with them, and then the publisher sells the papers back to the very same community that's given to them for nothing. Now, I've worked in the publishing industry, and my salary's been paid by that exercise, and I think it was somewhat valid when publishers had a real role, because they were the people who knew how to buy paper, put things on paper, print it, distribute it, and run subscription systems and all those things. Those days are fast disappearing. I'd say have disappeared, certainly in science, because everything can be distributed by the internet, and most of the traditional things that publishers used to do have gone. So we're trying to, what we're trying to do as a publisher is make all papers openly accessible. They should be free, no cost, and they should be freely available in the sense that papers don't belong really to anyone. The copyright should reside with the author, not with the publisher, but the author, in agreeing that paper is going to be published, should we feel grant to any third party in advance the right to reproduce or disseminate the paper, to put it in a database, a particular database of genomic papers or this database, so that with a great advantage that those databases can then be mined for information in ways we can't even imagine yet, and you don't have to go off here, there, and here to find different papers. So we have a strong view of what open access means. As a publisher, we've got to prove we can make a business out of this. Clearly, if we're getting no toll for reading, then we have to get our money from at the input end. So our view is charge the authors for publishing. Everything has to be peer reviewed. It's not vanity publishing, but if the peer review barrier is passed, then there is a charge associated with publishing. We believe this charge can be as low as $500, which may sound a lot to some of you, but certainly to a scientist who's probably spent $100,000 on the research that's gone into the paper, $500 isn't much. To us, whether the money comes out of the grant from the researcher or whether, as seems to be the more successful model in what we're looking at, it's going to be paid for by the Institute on behalf of the people in the Institute, we don't mind. It just has to come from somewhere. This is our challenge at the moment, which we've got to see if we can really make a business out of this. But if it works, it means that all scientific papers are freely available to everyone, which can do nothing but improve the speed at which science progresses and benefits come from it. So yes, there are plenty of issues about access to genomic data before and after publication, but I think we also we need to think about the access to the papers on which are built on that data. Thank you.
Thank you very much, Peter Newmark. Our next speaker is Dan Drell, who is a biologist in the Department of Energy's Office of Biological and Environmental Research, which manages the Department of Energy portion of the Human Genome Project. Dr. Drell provides oversight for a number of programs that pertain to the subject of this conference and beyond. including his office's program devoted to ethical, legal, and social implications of the Human Genome Project, focusing on privacy and confidentiality of genetic information, intellectual property issues, education, and the societal implications of complex multigenic traits. His other areas of responsibility include oversight of the microbial genome program, the biomolecular sciences and engineering element of the natural and accelerated bioremediation research program, and several other initiatives within the OBER. In addition, Dr. Drell helps edit the Human Genome newsletter, the Human Genome Program reports, and the new Microbial Genome Report. He received his PhD in immunology from the University of Alberta in Edmonton, Alberta, Canada. Dr. Drell.
Thank you.
Thank you very much. I want to begin by thanking the organizers for this opportunity to participate on this panel. And I want to mention by name Lauren Dame, Bob Cook-Deegan, and especially Susan Booth. As an aside, my wife back in Washington is a meeting planner for a trade association. I know perhaps a little more closely than some of you some of the headaches associated with planning a workshop and making it run as smoothly as this one has been running. And so I want to make that acknowledgement to Susan. She's done a great job. I'd like to discuss some thoughts on the issue of genomic data, publication access, and secrecy that are an abbreviated version of a commentary that Dr. Ari Petrinos and I wrote for the June 6, 2002 issue of Nature. I have to say this, these reflect our views, not those of the Department of Energy or the U.S. government. The office in which we serve, the Office of Biological and Environmental Research at DOE, is the steward of about $500 million of your money. And as such, our responsibility is to oversee and manage its spending for the greatest good to the U.S. science effort in service to Department of Energy missions and, by extension, the citizenry of the country. Our office supports research in various scientific areas, among them environmental sciences, global climate research, medical technologies and imaging, and genomics, including the Human Genome Project that we initiated in 1986. Among other things, though, this means that we work hard to adhere to practices and policies that promote the openness of data access, because we believe very strongly that experience has demonstrated that, with apologies to Ivan Boesky, openness is good, openness works, and that this maximizes the benefits to all of us. In nothing that follows should you think that we differ from that basic perspective that the freer and more open data is, the better. But, as Bob talked about before the break, we have to recognize and adapt to new realities. As one of the background papers for a recent National Academy Symposium noted, the overall expenditures by the U.S. government for fundamental, whatever that means, research is vast. It could be in the order of $45 billion a year. Less recent figures, the ones that Bob noted for fiscal year 2000, suggest that within genomics, as however that's interpreted, the U.S. and other governments invest on the order of $1.6 billion, and the private sector invests about twice that. It's a clear fact, then, that the expenditures on post-fundamental or exploitation-focused research by the private sector are, at the very least, comparable in magnitude and very likely more than what the federal government supports. What the private sector chooses to do with the research results and their data is up to them. I just have to accept that, I think. And as more private sector funding goes towards upstream science and the distinctions between what's research and what's development blur, the challenge we face I think, is not to decry the situation, but to explore ways of bridging it that in ways that promote science. And I think there are reasons for optimism that this can be done. Now, as you all well know, in February of 2001, two very significant papers were published, one in Nature and the other in Science, reporting the draft sequence of the roughly 3.2 billion base pairs that constitute the human genome. The Nature paper derived from a multi-year effort of the International Human Genome Sequencing Consortium, led by the U.S. National Human Genome Research Institute and the Department of Energy, but also incorporating the British Wellcome Trust and a number of other partners, while the Science paper resulted from the recent effort of Celera Genomics Corporation, a private company based in Maryland. Now, while the consortium had practiced since the mid-1990s a policy of unrestricted and rapid release of data and deposition into a sequence database, Celera did something different. They put their data on their website and, upon publication in Science, concluded a limited access arrangement. In my view, not a particularly restrictive one, but still one that was distinct from the tradition of completely open publication. More recently this year, Science published two additional papers focused on the rice genome sequence, one with Syngenta International Company's Torrey Mesa Research Institute, and their paper was published with similar limitations on data access. A lot of controversies resulted from these policies, and we think this presents a challenge to make constructive suggestions for ways to move forward that we hope might reduce the impasse and perhaps promote greater data sharing to the benefit of all. One possibility that has been proposed in a number of contexts is to start some kind of a clock or a timer on the deposition of certain data whereby a journal or some other depository agrees to restrict access to the source data underlying a paper for a specified duration. Another option is that the data could be housed with a trustee who ensures that the data are indeed deposited for the agreed time. Careful provisions would be needed both for how long the clock is set to run as well as for precisely when it starts. But the idea is to permit a set duration during which commercial exploitation can occur, up to and including patent applications and so forth. The U.S. Patent and Trademark Office allows up to a year before a provisional patent application is converted to a utility patent application, and this may be a model for this kind of concept. And there have been similar practices in the past at databases like Protein Data Bank. The responsibility for implementing a scheme like this could rest with the journal, and after Peter has talked, will not expand on what that might entail. I'm not the most competent here to do that. Or it could rest with some respected nonprofit. That could be worked out. You can envisage many potential trustees for this. And the idea is then when the clock expires, the data become fully accessible. It'd be fun, in fact, very useful to know the consequences of varying clock periods, as well as just how much privately held data actually contributes to the commercial viability of a company. And these are studies that would be useful to do. We need to recognize that as time goes by, data lose value, both as new discoveries, and in particular new technologies for the reacquisition of old data come along, and as science, as is its habit, proceeds unpredictably into new areas. A clock mechanism would allow a company to publish valuable data that would otherwise remain private while offering some protection for a limited duration for that company to use its data. Understandably, this role might be uncomfortable for journals or trustees, so it's important to explore fully a mechanism that all sides would have some confidence in. An added concern that has to be mentioned, especially since October of last year, is that there may be implications derived from at least some kinds of biomedical research in this day and age for national or international security. For example, a sequencing project of a pathogenic microbe where you do not want to publish those fragments of sequence that you're using for detector devices. And that has to be considered too. I can say something about a legal research exemption. I will just gloss over this and note that I think some kind of a legal research exemption is worth establishing. Obviously, a lot of details would have to be worked out as to its specifics. There's an urgent need, though, to find ways of giving incentives to the private sector, which we must recognize now controls vast amounts of valuable data that don't, at least to me, appear to have any obvious short-term commercial value, but would be of enormous potential research value. Most of the human genome sequence, you heard Craig Venter say it was 98.8%, I think. Whether it's 97 or 98% is trivial in this context, is apparently non-coding. My question is why allowing greater access to this part of it would threaten a company that had produced it. If what the company's interested in is drug development, which means they're really interested in the expressed portions that lead to proteins, what motive do they have in keeping tight access on the rest of it? Another point is that the sheer volume of data from high-throughput sequencing centers challenges even the most advanced and sophisticated labs to mine it for value within reasonable lengths of time. So, can the incentives be defined that would induce the Celeras and the Syngentas and companies like them to relax access restrictions on the part of their data that would seem to have less commercial impact? The most important point I want to make here, and I think the most important point that we try to make in our Nature commentary, is that this is a question that deserves to be explored. Not that I have any received wisdom on the best way forward, just it's a question that should be asked. Because the benefits, if we get it right, would move in both directions. Academic expertise would become more available to private sector companies, and the science carried out in the private sector would become more available to academia. So this should be a win-win for both sectors. There are a number of precedents. Some have been touched on, so I won't go into any great detail. We've heard mention of the SNP consortium. Before that, there was the IMAGE consortium involved with cDNAs. These appear to me to have been very successful forms of cooperation between the private sector and academia and government, and I think they could be useful models for additional directions. Another instructive example, one that's representative without being necessarily unique, comes from the Keck Graduate Institute in California, where industry-sponsored research carried out at the Keck involving Keck faculty is built upon carefully negotiated contracts. Both parties work out who does what, when and where, and who will own what results. Of particular concern is the role of students, whose educational needs necessarily must take precedence. And this means carefully working out disclosure issues and rights to publish so that the attainment of their degrees is not restricted. More than anything, this requires that the parties involved define a work plan with benchmarks and milestones and the terms of a mutually acceptable contract. In other words, they make a contract. It's that simple, or complex depending on the conditions. While this isn't always easy and the exact conditions need to be tailored to the specific parties and their needs, the Keck has succeeded in using negotiated contracts with private sector companies to attract research support, advance both the scientific work of their faculty and the education of their students, and contribute to the commercialization of scientific knowledge. Practices such as this are not uncommon, although they don't gather the publicity that the disputes do, and I would inquire purely out of ignorance what Duke's policies on this might be. So where we're going with this is that, are there some constraints on data access that are acceptable in place to not seeing the data at all? We think there are. We think that the academic community can compromise. Terrible word, but one that I think has some promise here. That if it's willing to forego instant access to absolutely everything, they'll get some access to a lot, which is better than no access to anything. If this is to be the direction, then I think we can work towards that win-win where everyone is a little bit unhappy as opposed to one side being fully happy and the other not. There are a variety of practices among different genomics firms. There are those that don't publish any data and treat everything as trade secrets. I think the question to ask is that the wisest policy? Does that work? If they want to do that, that's their right. I don't think we can avoid that. What we should be thinking of is how to create incentives for companies to publish data when they choose to and to facilitate such publication within proprietary restraints rather than clamoring for policies that will push firms towards a non-disclosure. Sir Isaac Newton is widely credited with the observation that if I have seen farther than others, it is because I was standing on the shoulder of giants. And I think the steady progress of science is founded on the traditional concept that individual scientists assemble knowledge brick by brick. We think that full and unrestricted access to fundamental research data should remain the guide star of science because centuries of experience suggest that it is the most efficient approach to promoting scientific progress and realizing for everyone its many benefits. However, we must also accept current realities. At no time has science ever been the exclusive province of those in academia. However, today, the proportion of high-quality science taking place in the private sector is very impressive. And Bob Cook-Deegan showed a list of some things, the invention of PCR technology, other developments that came out of the private sector. One can mention Crelox technology as well, that really establish that the private sector can contribute a lot. The potential for productively collaborating with the academic or government scientist is greater than ever before. I don't think we should bemoan this. We should welcome it. We should work with it. Private sector science has its legitimate interests too, and while the government and academia has a terrific record of carrying out fundamental research, I don't think most of us would disagree that it's the private sector that's really good at developing that into something that goes into a bottle for sale. So, our conclusions are as follows. The first is that, as I've said, openness by and large as a guide for public funding of fundamental basic research is a very successful policy because it generates data that in unpredictable ways leads to exciting insights into nature's workings. We're all in favor of that. It is the appropriate role of the private sector to exploit open basic research to develop and commercialize valuable products. It's what the private sector is good at. I don't mind saying, as a representative of the Department of Energy, it's something the Department of Energy is not particularly good at. The amount of private sector investment is large and in many areas exceeds that of the public sector, and the quality of their work is very high. We need to aggressively explore compromises and quid pro quos and accommodations to attract private sector companies to loosen their hold on that portion of their data that can benefit fundamental research, but in ways that do not threaten their legitimate intellectual property concerns. And I think by working together and exploring this issue, we can find ways to do that. I've suggested a couple of mechanisms, the clock, etc., none of which are particularly novel, that might take steps towards increasing private sector, public sector collaboration. But as I said, my most important point is we should be looking at this. The mechanisms I've suggested aren't necessarily novel. Many of you are probably much better placed to think of more creative and effective mechanisms. All I advocate is that we start thinking about them. Different schemes, timers, trustees, et cetera, can be put to experimental test to learn which work better with what partners and under what circumstances. And this is the exploration that I suggest is worth undertaking. And lastly, if we succeed, the scientific and financial benefits can be enormous. If we fail, the costs are not trivial and are avoidable. I think that's the perspective we should take. Science is going to continue to advance regardless, but I think there are some interesting explorations we can carry out to make it advance here as well. Thank you.
Thank you very much, Dan Drell. Our third speaker is Jerry Reichman, who is a leading member of the IP powerhouse here at Duke Law School. He's Bunyan S. Womble Professor of Law at Duke Law, where he teaches in the fields of contract and intellectual property. He's written and lectured widely on all aspects of intellectual property law, including comparative and international intellectual property law, and the connections between intellectual property and international trade law. He serves as special advisor to the National Academy of Sciences, the National Academy of Engineering, and the International Council for Science on the subject of legal protection for databases. He's an academic advisor to the American Committee for Interoperable Systems, a consultant to the technology program of the UN Conference on Trade and Development, and was a consultant on the UN Development Program's flagship project concerning innovation, culture, biogenetic resources, and traditional knowledge. The first part of his most recent monograph, entitled Non-Voluntary Licensing of Patented Inventions in Canada and the United States, has just been released by the UN Conference on Trade and Development. Jerry Reichman.
Thank you. It's a pleasure to be here. Forgive me for speaking from the desk. I picked up a whopping Berlin flu and I'm giving it to everybody, so I'm better off here with a glass door around me. My topic today is scientific data as a private good, pressures on the public domain. And it is drawn from that larger framework paper that Dr. Drell talked about that Paul Euler and I presented at the symposium at the National Academies a couple of weeks ago. The symposium was entitled Role of Scientific and Technical Data in the Public Domain. And our study, which is trying to work at the problems that Dr. Drell rightly identified, is entitled A Contractually Reconstructed Research Commons for Scientific Data in a Highly Protectionist Intellectual Property Environment. It's divided into 4 parts. In the first part, we map the public domain in scientific data as it has functioned until recently, and as it could function in a digitally networked environment. The theme there was all the good things that we can do given these cooperative norms of science and the traditional structure of the public domain, in which scientific data and technical information are primary ingredients that fuel the public good functions of science. We show how the traditional legal and scientific norms have advanced these functions, and we also show how today, even more dramatically, new technological means make it possible to share data in exciting ways that were not possible before, assuming that the legal structure remained constant. In particular, we can link these disparate data holdings that these laboratories have in peer-to-peer file sharing arrangements and create universal data archives that boggle the mind. We can Napsterize the whole process. However, in part 3 of our study, we discussed the bad news. That is, the legal, economic, and technological pressures on the public domain. There we explore the risk that the research commons may simply disintegrate if present modes of treating scientific data as a private good continue unabated. And then in part 4, we make detailed proposals for enabling the scientific community to organize and manage its own data supplies with a view to avoiding the negative synergies we foresee and to contractually reconstruct its own research commons. And also, I must say, the final part deals with ways to encourage further disclosures from the private sector as you have proposed. Today, the organizers have asked me to concentrate on the bad news. That is, to talk about the economic and legal and technological pressures on the research commons that we find most alarming. And this, of course, especially includes the prospects for a new sui generis, that is, special intellectual property right in databases that would enable both scientists and publishers to retain ownership of the data even after they publish it in your database. So this is going to radically change the whole situation, and people seem unaware of how close it is because it is already a reality in Europe. But let me start at the beginning and work up to that development. Information has become an exceedingly valuable commodity in an information-based economy. That's a truism, but you need to think a lot about that. And because of that, science finds its basic data supply caught up in what Jamie Boyle has in another talk broadly called the second enclosure movement. That is, the drive to fence the information commons. Duke Law School held a major conference on this topic in November, and the papers will soon be published. The digital revolution makes investors acutely aware of the heightened value that collections of data and information may acquire in this new economy, and investors are doing everything they can to capture and market data and information as raw materials or inputs into the downstream stages of the innovation process. Now, what I'm going to talk about today is first the economic pressures to commodify data in the public sector, and then I'm going to focus a lot on legal and technological measures that endow private database owners with these new proprietary rights and novel means of exploiting facts and data that copyright law traditionally left in the public domain. You should not think for a moment that the research community is extraneous to these developments. Of course, if you've been at this conference these last 2 days, you realize they are in it up to their necks. That means the developments that I'm talking about pose very serious conflicts between these wonderful norms of science and the norms of private industry. And our contention and underlying theme is that if we don't recognize these conflicts and we don't balance these interests in time, we will not only undermine the scientific enterprise, but we risk undermining the entire national system of innovation, which depends in the United States integrally on the underlying scientific enterprise. First subtopic is reducing the scope of government-generated data, and this has to do with the trend of commoditizing data produced by public science during the last 10 years has resulted in a marked tendency to shift the production of science-relevant databases from the public to the private sector. Partly you argue, or you would like to think, that that's because of budgetary shortfalls, but that really is not as clear as it seems. There is a political side to it, political pressures on the scientific agencies to privatize their outputs. Now, until recently, what happened? It was customary for an agency to commission a system to be produced by the private sector, but then it would be operated and run by the public sector, in which case the data is owned and managed by the public sector under the open access norms that are codified in US law. But the new tendency today is that industry has successfully pursued a strategy of providing an independent supply of the government's data needs and then retaining ownership of these products on a licensing basis. This is called productization. Now, as a result of that, when that happens, control and ownership of the data remain in the hands of the designated private company. They license it to the government, and those licensing arrangements do not typically provide for the research function, let alone other public good aspects. So one consequence of these trends is a lessening of the variety of databases that are going to be produced, and a second is a reduction of the quantum of data that are produced becoming available for research purposes among those databases that are produced. So this is a trend of some concern. Second subtopic is commercial exploitation of academic research, where now we're talking about government-funded data, most of what you've been talking about today. This has to do with the progressive incorporation of data and data products into the general commercialization process underway in academia that we associate with the Bayh-Dole Act and related acts that R.D. Rai has written about so eloquently. Now, let me say, first of all, I'm not up here to tell you that Bayh-Dole is a bad thing. I'm a strong supporter of Bayh-Dole, but as Cook Dagan said at the Academy meeting, it's so successful that we're having a lot of unexpected consequences, and this is one of them. And we're going to have a lot more and a lot of bad ones if we just sit back and let it apply to data products as it has applied to patents. We can see that already in molecular biology, where databases have become sources of patentable inventions, and there's even more potential value in the use of these databases as research tools. And this is a very controversial topic. The point I want to emphasize at the moment is that in dealing with databases under the profile of the general principles of Bayh-Dole, the university technology transfer offices have so far applied a very strange form of default rule indeed. That is, their database licensing arrangements tend to favor strong exclusive arrangements under onerous terms and conditions that include restrictions on use and even reach through clauses claiming ownership interests in future applications. Well, this is a sign of the future. This odd inter-university strategic behavior is just, in our view, a portent of sign of an early sign of much bigger things to come. Imagine what life will be like when we have a codified database right underneath those data, and not just a copyright law that injects them into the public domain. And when that data right allows researchers to control their data even after publication, which is what I'm going to address in a moment. These trends pose serious problems for the research community's ability to access and use needed resources under any condition, and the tensions are going to be much greater given the new legal and technological fencing measures that I want to focus on now. So my third subtopic is intellectual property rights, e-contracts, electronic contracts, and technological fences. Let us review some of the dramatic changes that have occurred in this overall environment lately, changes that make it possible to assert and enforce proprietary claims to virtually all the factual matter that previously entered the public domain under classic copyright law. So let me talk first in general, and then we'll talk about database rights in general. The first surprising development is a number of recent cases that greatly expand copyright protection of factual compilations, something you might think of as a revolt against the Supreme Court's 1991 decision in the famous case Feist v. Rural. In that case, the Supreme Court said, well, you can't copyright the facts in the white pages of a telephone directory, and that has widely been understood to mean that most scientific databases are uncopyrightable because they are random assortments of data organized in no particularly creative, with no particular creative selection and arrangement. And the Supreme Court first said that only the creative selection and arrangement is protectable, and then, more important, most people miss this, the more important part of the holding, it said that even if there is a creative selection and arrangement, second-comers are free to use the disparate data in making their own databases. So basically, they envisioned a bare, sort of unfair competition right against wholesale copying. The surprise we encounter lately is an increasing resistance of some important federal appellate courts to this holding. Increasing maneuvers now coming out of the Second Circuit and the Ninth Circuit, where panels have been over backwards to find that not only are data compilations protectable in many cases where we cannot imagine anything creative, but that the little bit of selection and arrangement that the judges invent for themselves, it pervades the data. So second-comers cannot use the data even for functionally important purposes. Basically, these federal appellate courts are, in effect, protecting algorithms. So one tendency that is going on is that our two leading copyright courts are converting copyright law into a kind of roving unfair competition law, but hold it, that is still a copyright law in the sense that owners enjoy long terms of protection, life plus 70 years, and powerful derivative work rights that allow them to control follow-on application. Now, once you realize that copyright protection of factual compilations is expanding against the expressed will of the Supreme Court, that calls into play another development in copyright law, namely the Digital Millennium Copyright Act of 1998, which reinforced technological fencing devices for online delivery of copyrightable works. Once any compilation attracts copyright protection and is delivered online, it also attracts these new super forms of protection. Now, what is at stake? Well, if you surround the copyrightable compilation with a technological fence, say an encryption device, then you drive would-be users through an electronic gateway. And there you meet them with an electronic contract, a one-sided electronic contract. And that contract says, never mind the rights that you thought copyright law gave you, ID expression, non-protection of facts, fair use, exemptions for reach. Never mind all that. If you want access to our data, you waive those rights and you accept the countervailing conditions that I impose upon you with this electronic contract. Take it or leave it. And as you know, every time you go to the bank to withdraw money, you always take it because you cannot leave it. So now you say, well, wait a minute, I have rights. Jamie Boyle told me that I have rights. So I am going to take my electronic hatchet and chop down your technological fence in order to exercise my rights under copyright law. And that is exactly what the Digital Millennium Copyright Act of 1998 says you cannot do. If you interfere with that technological fence, you automatically become an infringer no matter what else you do, an infringer of copyright law, and you might very well go to jail. The DMCA says you cannot alter or circumvent these technological fencing devices and the digital rights management technologies which implement the licensor's objectives. So this is a very powerful barrier to the exercise of your legal rights. You simply cannot assert them because barring them is a new right that never existed before, a right of access that trumps all your other rights. Then, of course, on top of that, you have these one-sided licensing contracts, and if you look at them, you understand that what the internet succeeds in recreating is the power of the two-party deal that was lost when Gutenberg created the printing press. Before the printing press, anybody who wanted to look at your work had to sign a contract with you. Okay, then comes a printing press, and you have these thousands and millions of copies over which you have no control. So copyright law gives you a set of default rules which control access to those copies made in series, but they impose a balance of public and private rights, not what you want, what the state thinks is a fair deal. But now the internet makes it possible to actually override that public deal and impose what I call privately legislated intellectual property rights one by one. And the question is, will they be enforced? In general, unfortunately, the courts have been enforcing them. And if Microsoft has its way, this new proposed Computerized Information Transactions Act, known as USITA, Uniform Computerized Information Transactions Act, a proposed uniform state law, will make all of these contracts absolutely enforceable. That is being opposed, however, by 16 attorney generals, the same ones that are suing Microsoft elsewhere. We don't know whether it will be adopted. So anyway, up to this point, we have a very powerful legal cocktail. The only thing that could make this legal cocktail more powerful is if publishers actually had an exclusive property rights in that data itself, regardless of copyright. That sounds unthinkable. It conflicts with the very premises of intellectual property law as we inherited them historically. But we now have such a right. It was codified in the European Union in 1996, and some 50 countries seeking to associate with the EU will adopt this very strong exclusive property right in collections of data. And the 6 companies that got it over there are knocking themselves out trying to get it here. We, of course, are knocking ourselves out trying to stop them. We have stopped them for 6 or 7 years, but don't count on it. So let's talk about this sui generis intellectual property right in collections of data. In the interest of disclosure, I'm a terrible critic of how the Commission of the European Union handled this. But let me, in all candor, also say that to solve this problem of how to protect non-copyrightable databases, this presents one of the hardest problems intellectual property has ever faced. And it would take men and women of goodwill a long time to sit down and work it out. They didn't spend a long time. They waited in, lobbying prevailed. The Commission, operating in very untransparent circumstances and at a time when, let us say, in all frankness, its procedures and integrity have subsequently been called into question, they cut this discourse short by adopting a directive on the legal protection of databases in 1996. This requires all member countries and affiliated states to pass laws that confer a hybrid exclusive property right on publishers who make substantial investments in non-copyrightable collections of facts and information. Let me summarize this law. To begin with, it has a definition of databases that the mind of man could not make more broad. So immediately, everything is a database. Your newspaper is a database. My article is a database. So immediately, you have this incredible overlap with copyright law. And you start to worry about that overlap because in most instances, the same things that will be copyrightable will also have attributes of databases, and if the database law turns out to give stronger and longer protection in the end, it will control everything. Now, how does one qualify for database protection? Well, you just invest time and money. You make a substantial investment as measured in qualitative or quantitative terms. End of story. Well, you say, surely there must be some model for that. And the answer is no. There has never in history been an exclusive property right based on investment alone. Investment entitles you to compete. That is the Manchester School. The only form of protection for investment that we know are trade secret laws, which are liability rules, not exclusive property rights, and trademark laws, which are liability rules and not exclusive property rights. To qualify for an exclusive property right, historically, you had previously to contribute some advancement of knowledge, either a literary work, a work of art or literature, or a patentable invention. Today, instead, in exchange for mere investment, normally subject to free competition, our European data publisher gets two very, very strong exclusive property rights. An exclusive right to extract or to utilize all or a substantial part of the contents of the projected database. Extraction and utilization. Extraction right covers any transfer in any form of all or a substantial part of the contents of the protected database, and utilization covers the making available to the public of all or a substantial part of the database. Basically, this covers everything except private use. That is, if you buy the database lawfully, you have a right to use it. That's some concession. It also covers very strongly derivative work right. It is an absolute right to control follow-on applications based on the existing database, and so far courts, particularly a court in the United Kingdom recently, has given a very strong interpretation to that follow-on derivative work right. So this creates tremendous barriers to entry. It allows the first comer to build what I call Arctic shelves or glacial shelves of data accumulating over time that gradually exclude competitors who cannot reassemble the collection from scratch. And secondly, it also applies, and this is very important in the EU, it applies to governments. Governments in the European not only own their data, they do not waive their copyrights or their intellectual property rights, as our government has always done with regard to government-generated data. On the contrary, they gleefully exercise their rights in government-generated data, and it is very hard to tell them that this is a bad thing because they see it as a potential cash cow. Now, what's his name gave that brilliant presentation at the academies on how much it's actually costing them by their short-sighted policy. Our whole national system of innovation is based on upstream government-generated data being free. We think they're making a huge mistake. There's no mandatory public interest exceptions in this law like those we know from copyright law. It has an optional but very ambiguous exception for illustrations for teaching or scientific research. Nobody knows what that means. The Nordic countries have tried to give that clause a flexible copyright-like interpretation, but the European Commission has sued the Nordic countries, saying you can't do that. Other countries, France, Italy, and Greece, simply adopted the directive and ignored any exemption for teaching, research, etc. The fact remains that under the directive, scientists or their universities or commercial sponsors will retain ownership to data even after a scientific article is published, unless those rights are waived. This presents a new fact of life that we think will greatly increase the pressure on scientists to hoard data and that are likely to undermine the open access and sharing ethos of public science. Now, of course, the directive does permit independent creation, but how easy is that to do in science? How often can you regenerate these one-time events, and how often can you get the money to produce the same event? Science builds on science. The whole history of science, especially with regard to databases, is to use databases as the way to solve every new problem. You take all the existing data, you chunk them all together, and you use that as a research tool to address that new problem. This stands in the way. Well, they say, well, okay, this sounds bad, but at least at the end of the day, we get the data because it lapses into the public domain, right? No, it never lapses into the public domain. Amazingly, the European directive went as far as it can go because every new investment in updating or verification or maintaining the database does not just requalify the new data, it requalifies the entire database for another 15 years. So we have, for the first time, perpetual protection. So this law broke radically with the history of intellectual property rights, And over here, very strong efforts have been made to get something similar. The last similar bill on the table is H.R. 354, the Coble bill in the Subcommittee on Intellectual Property Rights in the House. It is a very similar strong exclusive rights model. It looks different. It tries to achieve all the same things by language that's more congenial to the American tradition. Maybe we blocked the perpetual protection thing. We think we did because we have a constitutional clause there. We have not got any kind of valid exception for scientific research at all. I haven't time to go into details, but I do have a new article in the Journal de Droit Économique that goes into, in English, that goes into, the only English article in it that goes into very great detail about these situations. There is a second bill, an opponent's bill. It was known as H.R. 1858. It originated in the House of Commerce. It was proposed by opponents to show that they are in good faith, that they're willing to look at reasonable alternatives. It purports to be a minimalist, unfair competition law. It has some good things in it. The opponent's bill would prohibit wholesale duplication of a database, and it has some wonderful wholesale duplication of a database when the duplication is used in commerce. So most scientific uses would already be out because we don't use them in commerce, although research tools would get back in. It also has some wonderful language regulating contractual uses of this right, misuse language. It has a couple of bad things. The bad thing is that somewhere along the way a derivative work right got in there. So it will also apply to wholesale duplication of a part of a database, and the other bad thing is that it lasts forever. So it is not chicken soup either. Well, what will happen, what kind of a bill or what kind of a right we're going to get, we don't know. But Paul Euler and I don't think the scientific community should wait to find out. We've been fighting this for 6 years, now going on 7. We think that cooperative inter-university relations are extremely fragile. We think that if you add the pressure of an IPR in data into the cauldron, then a whole bunch of really bad things can happen. And in order to head that off, we have the fourth part of our article is all about ways in which scientists, the funding agencies, the universities, and the scientific bodies can get together now and devise a set of contractual templates of, if you will, of multilateral pacts based on open source software notions, based on this new Creative Commons that Jamie and others are involved in which we can create our own rules for sharing the data, and we can influence the relations between universities and the private sector in ways that will encourage even the private sector to reveal their data, and at the same time will keep them from controlling what the universities do. If we don't do this, we're going to end up having the private sector control what universities do to a much larger extent. That's another topic. Thank you for your attention.
Thank you very much, Jerry. Our last speaker is Alan Buchanan, who I'm delighted to say joined the Duke faculty this year as Professor of Philosophy and of Public Policy in the Sanford Institute. His main interests are bioethics and political philosophy. He's the author of over 100 articles and 6 books, including the 1999 book entitled From Chance to Choice, which deals with genetics and justice. He served as staff philosopher for the President's Commission on Medical Ethics, where he was a principal author of the Commission's 2 book-length reports on ethical issues in genetics in 1983, and he served as staff consultant for the U.S. Advisory Committee on Human Radiation Experiments, where he authored the Ethical Framework chapter for the committee's final report. From 1996 to 2000, Alan served as a member of the Advisory Council for the National Human Genome Research Institute, and he's currently director of the Consortium on Pharmacogenetics. His most recent book is Justice, Legitimacy, and Self-Determination, Moral Foundations for International Law.
I need a technical. Thank you. I'm very happy to be here. I've certainly learned a lot during this conference. Now, I was asked to talk about confidentiality and privacy of genetic information, and I've chosen to take pharmacogenetics as a case study to look at some of the issues of confidentiality. And I did that on two assumptions. First, that pharmacogenetics will be the first major application of genomic knowledge in drug research and clinical practice. And second, that the success of pharmacogenetics, both its commercial success and whether we do it in an ethically sound way, will require genetic confidentiality. That is, it will require us to solve some of the problems of confidentiality regarding genetic information. This is going to be very simplistic and obvious to a lot of you, but I think there's confusion about the terms pharmacogenetics and pharmacogenomics. There's no settled usage. So I'm just going to give this definition, then I'll define pharmacogenomics. Pharmacogenetics is the study of the effects of genotypic variations in individuals on drug response, including safety and efficacy, and drug-drug interaction. Pharmacogenomics, as I'm using the term, is the study of the influence of gene expression in particular tissues on drug response. So roughly the idea is that if you think about someone's stable genotype, pharmacogenetics looks at how that genotype affects drug response, whereas pharmacogenomics looks at something more dynamic, namely the influence of gene expression in particular tissues on drug response. A pharmacogenetic test is an assay of DNA designed to determine probable drug response to a particular drug or class of drugs so far as it's influenced by genotype. Now, what are the confidentiality issues in pharmacogenetics? First, there's the issue of confidentiality regarding collection and storage of DNA samples and related medical records. And Sharon Terry spoke about this and told us about some of the very innovative ways in which collection and storage and controlled access to DNA samples is being done by the Genetic Alliance. I want to focus on what I'll call the problem of secondary information that can come from pharmacogenetic studies or pharmacogenetic tests. The primary information that you try to get from a pharmacogenetic test is information about likely drug response for this individual given this individual's genotype. But in addition to that information, which you might call, as Alan Rosens does, the medicine response profile, you may get other information carried along with the pharmacogenetic test result. And some of this information, in some circumstances, can be sensitive and may require protections for confidentiality. You may learn, along with the medicine response profile, about a genetic disease that the individual who's tested has or about a genetic susceptibility to disease. You may learn something about likely disease progression and prognosis in that individual. And you may also learn that there's going to be greater cost associated with the medical care of that individual. I mean, if I have a serious chronic disease and I take a pharmacogenetic test to determine which drug or drugs might be helpful to me, and it turns out that none of the drugs that are efficacious for treating that condition are either safe for me or effective for me, then this medicine response profile, in fact, says that I'm going to be a very costly individual to insure. Also, since, like with all genetic knowledge, you're getting information about not just the individual tested, but people who are genetically related to that individual, there can also be issues about confidentiality for them. You may learn something about genetic risk for disease in other family members, or you might get some adventitious information about non-paternity, which is always a sensitive topic, to put it mildly. Now, what are some of the ways to reduce the risks of secondary information, the risk associated with secondary information? Those risks could run from insurance or employment discrimination to stigma, self-stigma, psychological disturbance at finding out that you have a strong susceptibility to some genetic disease when you just thought you were getting tested to see where you could take a drug. Well, the first strategy has already been talked about by the Terrys in earlier discussions, and that is the use of firewalls. Firewalls, as the name suggests, are designed to prevent the dissemination of sensitive information. They're to prevent it from getting out into the wrong hands. The first suggestion in the growing literature about pharmacogenetic tests was, well, let's just limit the information that comes back, say, to the physician after he or she has ordered a pharmacogenetic test. Let's just limit it to the medicine response profile. That is, this patient can take this class of drugs safely. Well, as I mentioned earlier, that's really not going to do it if the marker that was used to get the medicine response result is associated with other information. But nonetheless, there might be something to be gained by way of a kind of partial, semi-permeable firewall by trying to limit the information as much as you can to what's relevant to the choice of drugs. There's also, as another strategy utilizing the idea of a firewall, again, something the Terrys have talked about and know a lot more about than I do, the use of trusted intermediaries as secure but accessible repositories of DNA and related medical records. And it's important to emphasize the secure but accessible, right? You want to be able to have controlled access, and in particular, you want to be able to get information back to the individual if it turns out to be beneficial. So the challenge is to try to create trusted intermediaries which will use encryption or coding firewalls that will make the DNA sample and related information secure, but also accessible in ways that are beneficial to the individual who gave the sample and possibly others. Now, the second major kind of strategy, apart from firewalls prevent the dissemination of information. Regulation prohibits certain uses of information. And of course, these two strategies can work together. It's not a matter of one rather than the other. And right now, there's already a lot of proposals for genetic discrimination laws that would prohibit insurers and or employers from using genetic information or for using it for certain purposes. The third kind of strategy for reducing the risks of secondary information from pharmacogenetic tests is a little less obvious. I mentioned that roughly the problem of secondary information is that when you're trying to get information about the likely response to a medication, you may also get other information which is sensitive. Well, how much of a problem of secondary information there is may depend upon which markers you choose for the pharmacogenetic test. And in some cases, if you're lucky, it might turn out that there's a redundancy. That is, there's more than one way to skin the cat. There might be more than one kind of marker that you could use to get a reliable prediction about the response to a drug or class of drugs. But there might be a difference among the different markers. Some of them would be more replete with possibly damaging secondary information than others. I mean, you wouldn't want to use the ApoE4 gene as a marker for determining whether you're going to get much effect out of taking an antihistamine or something like that, right? Because this mutation carries with it some rather portentous information. Now, this raises an interesting question that I really haven't seen discussed. I'll come back to this in a moment. Well, I'll go ahead. I'm interrupting myself. I'll go ahead with this. What are the issues for each of these three types of strategies for dealing with the risk of secondary information? And again, none of them is going to solve the problem by itself. In fact, a combination of them is not going to reduce the risk to zero. But then, of course, we're not, if we're realistic, we don't worry about reducing risk to zero. That is, if we want to continue to live. Instead, we think about reducing it enough, and we pay attention to the marginal cost of risk reduction. Well, here are some of the issues regarding firewalls. If trusted intermediaries are used, should they be private or public, or should they be some of each? That's a huge issue. Should they be centralized or decentralized? Some people talk about a grid model versus a hub model. And they each have some attractions and some deficits. And given that you have already private repositories and public repositories and multiple private and public repositories, how do you achieve beneficial but secure exchanges of genetic information between private and public entities? And of course, this is complicated with private entities because they undergo changes of ownership. One swallows up another. The rules that one company might have used for the collection and storage and informed consent regarding biological samples may be different from the successor company. There are all sorts of of issues here. And I think that a sort of subtext of the Terry's presentation was that these are issues that really have to be talked about. And we already have some experience, partly based on what they've done, but also what other groups have done, of seeing how trusted intermediaries work and how and which sort of firewall arrangements are best. Now, these are some sort of obvious points about the second strategy, the prohibition on uses of genetic information. A lot of people have worried that if insurers are barred from information about genetic risk, but individuals aren't, if you have that asymmetry of knowledge, then you'll get adverse selection in the insurance market and a kind of death spiral of adverse selection. For example, if I find out that I have a very strong genetic predisposition to Alzheimer's dementia before the age of 60, then I may take out a lot of long-term care insurance. And by the way, of course, insurers aren't worried about your having information about genetic risk. They're worried about your having and they're not having it. It's the asymmetry that's the problem. Also, stringent restrictions on access to genetic information about individuals might actually be unfair in some legal contexts. I recently have read some interesting things about toxic torts cases where a plaintiff might want to use a genetic test to bolster the case that the disease that the plaintiff is suffering from was caused by some toxic product in order to sue the people who made the product or who distributed it. There's kind of a rub here, because if the plaintiff succeeds too well and shows that he or she was hyper susceptible to the toxic agent, then this may be a boon to the defense, who will say, well, you couldn't have expected us to produce a product that would be completely safe even for people like you. But on the other hand, there have already been some cases where the defense has come back and said, well, we're going to do a fishing expedition and look into this person's genome, and we ought to be entitled to look into it because you're using information about the individual's genes. And when it comes to your assessing the damages for the toxicity that you think we've caused, we're going to have those reduced if we find out that this individual had a genetic susceptibility to some lethal disease. So when you calculate the damages in terms of expected quality life years, it's going to be a lot less. So if it looks, I mean, it seems to me, and I'm not a lawyer, and this is perhaps a naive view, but that if you're going to allow individuals to use information about their genotype for certain legal purposes, then it may in fact be unfair to disallow, to prevent other people from using information about the genotype in this kind of situation. So that greatly complicates the question of genetic confidentiality. Now, I mentioned earlier that, you know, if you're lucky when you're devising a pharmacogenetic test, you might have some alternatives as to how to get the prediction about the drug response. And that would be nice if you had a choice and you could choose the clean marker, the marker that carried the least sensitive secondary information. But what about a situation where the cleanest marker isn't the one that gives the most reliable test result? There's a trade-off question there, and there's a question about who should be determining how the trade-off should be made. And right now, there's no structure for even thinking about this as far as I know. A final complication, and this has been something that I think hasn't been talked about enough during this conference, which is supposed to be about commercialization of the genome. It was, there was some contact made with this in Patrick Terry's emphasis on a kind of consumer revolution in genetics. But the most extreme form of the consumer revolution in genetics might be the growth of direct marketing of self-administered pharmacogenetic and other genetic tests. Other genetic tests, I mean genetic disease susceptibility tests in particular. And there are already a number of companies, and every time I look into it, there are more of them, who will provide you with genetic tests without any physician intermediary at all. you just get a little test kit from them through the mail after accessing them online. And the test kit has a little swab to run around the inside of your cheek to get some cells, and a little Ziploc bag you put it in, and a self-addressed Federal Express envelope to send it back to them in. And you can get anything from a battery of pharmacogenetic tests to tell you your likely response to a dozen or more prescription and non-prescription drugs that are fairly common, to a genetic test to see whether you have any of the 3 mutations for hereditary hemochromatosis, to genetic susceptibility tests for other disorders. And I think this is going to change everything. Now, it might not. It might be that this burgeoning market would get cut off. It could get cut off in at least 2 ways. One, by very restrictive regulation, which just forbid people to do this. The other would be if the lack of a learned intermediary created such liability problems that people who otherwise would be interested in providing these self-administered tests would fear that they would be liable and that they couldn't deflect the liability by appeal to a learned intermediary because there isn't one. But I don't see any evidence right now that either of those things is on the near horizon. Instead, it looks like there's going to be a growth in this. And one thing I think that's important to remember is that pharmacogenetics can be defined either broadly or narrowly. Narrowly, it refers to correlations between genotype and drug response, but by drug response is meant something like, medicines. But of course, the same methodology can tell you about the correlation between genotype and how you respond to foods, to recreational drugs, to dietary regimes, to tobacco, to all sorts of things. And I would predict that unless there's some chilling regulation or some problem about liability because of the lack of learned intermediary, there's going to be a booming business in sort of not just having your personal trainer, but having your personal pharmacogenetics agent who will take a sample of your DNA and tell you which over-the-counter vitamins and botanicals you ought to take, how many grams of protein you ought to eat every day, whether you can smoke cigarettes with minimal risk of lung cancer, whether you're likely to become addicted to cocaine or just be able to use it now and then recreationally with no ill effects. There's a huge potential market for this, and the interesting thing is that it's something that's hard to think about by people who've been thinking about, excuse me, regulating genetic tests, because they've typically been thinking about regulating tests within the framework of the medical gatekeeper model. You take the medical gatekeeper out, it's a whole new ballgame. Well, I've just scratched the surface, and I'm glad I made my presentation short because we were running late, and it's the last presentation of a long conference with a lot of information, and we still want time for people to have discussion. Some of the material that I used, this is all just in the name of fair disclosure. Some of the information I used in this little talk came from work that I did as director of something called the Consortium on Pharmacogenetics, which was funded by an unrestricted grant from GlaxoSmithKline, IBM, and First Genetic Trust. GlaxoSmithKline is pretty obvious why they would be interested in this. Why do you think IBM was interested in this kind of thing? Bioinformatics. What's First Genetic Trust? Anybody know what that is? It's kind of a cute name, yeah.
Well, I'm not going to answer the question.
Oh, go ahead.
First Genetic Trust is actually a private corporation that's doing one of these firewall things along the lines of what
A trusted intermediary
Yeah.
Operation. So I think in the next few years we're going to see a lot of competition among trusted intermediaries and heightened awareness of the question about whether we should have a mixed private-public system, a decentralized or centralized system, a grid or a hub system, and what should be the terms under which trusted intermediaries work. So if you're interested in more of this stuff, I can tell you how to get hold of this report. Thank you very much.
Thank you, Alan, and I want to thank all four of our presenters for giving very interesting and engaging presentations, which were also succinct and have left us some time for questions and discussion. So we've heard from Peter Newmark about how technological change, both in IT and biotech, may have made publishing as we know it obsolete, and a need to rethink how scientific information is disseminated. We've heard Dan Drell's proposal for a sort of spirit of compromise between academic and industrial researchers, and Jerry Reichman's considerably darker picture of a powerful legal cocktail that is threatening to destroy the research commons. And then finally, Alan Buchanan talking about how confidentiality and restricted access to individual genetic information can be critically important to protecting people from harm, but also raises complicated balancing issues as well as problems of asymmetrical access, and points to the potential for the breakdown of the medical gatekeeper model. So lots to think about, and the floor is open. Lauren.
Question. This is directed at Alan mainly. A couple of times things have come up talking about direct-to-consumer marketing of genetic tests, and what I find interesting about that is there are two sort of very conflicting views on that just from the consumer group itself. When I worked at Public Citizen in sort of consumer advocacy, we were very upset about direct-to-consumer advertising for pharmaceutical drugs because of concerns about the drug company, having a lot more savvy PR and everything. I'm just interested in, after you've looked at this, what you think about direct-to-consumer genetic tests when we know that there are all sorts of issues about genetic testing that people might not understand the implications of.
Yeah, I think the first thing to notice is that not all genetic tests are the same, and that some of the very reasonable concerns that you might have about a through-the-mail test for the Huntington's gene, for example, or ApoE4, might not have the same weight for testing for some fairly mild susceptibility to a disease that can be managed in some way, or even a disease like hereditary hemochromatosis where you get a definite result, but it's easily treatable and can be effectively managed. So I think the first thing is to avoid sort of genetic homogenization, thinking that all tests are the same. That complicates things, but it's a complication I think you can't do without. Now, one of the things that's worried me about some of the through the mail, not just direct marketed, but self-administered tests without any physician intermediary, is that sometimes parents are sending genetic samples from their children, their minor children. And this is actually done, has been done at the Human Genetics Lab at Michigan State, which has a hereditary hemochromatosis test through the mail. And they reported, without even blushing about it, that they had tested DNA from a lot of children that had been sent by their parents. And this is very problematic for a number of reasons, one of which is that the disease almost never manifests any symptoms until late middle age. And so the question is, well, what good is it going to do to know this? And it may do some harm by attaching a stigmatizing label, although that disease doesn't tend to be as stigmatizing as some. So that's one issue. The other issue is that one of the reasons people do these self-administered tests is that they don't want a record of it in their regular medical records because they fear discrimination, insurance discrimination or employment discrimination. But we don't know anything about the conditions of confidentiality, if they exist at all, in through-the-mail test operations. I mean, they might be selling your samples to somebody else for research purposes, or who knows what they might. There's just absolutely no control on it. And there's also no control over the quality of the test if they're using home brews, if they're making up their components, putting their components together for the test. So it's really wide open, and that makes people fearful. On the other hand, I think there's been some excessive paternalism about genetic tests and too much of the medical gatekeeper model, and also a lack of sympathy for people who really don't want to have it in their regular medical record. And these through-the-mail tests are actually not very expensive for the most part. They're probably less expensive than you might pay for them if your insurance covered them. In many cases, your insurance won't cover them. So there's some legitimate interest that people can have in having direct access to their information about their genes, but there are also some dangers. And I think it's not a simple thing. They should all be prohibited or yes, just let it rip. It's going to be a much more nuanced answer.
Dan, you wanted to address
I
that?
want to add a comment to this. I agree with everything that Alan said, but I think there's a still earlier level of concern about genetic tests. With rare exceptions, and Huntington's disease is probably the most prominent, most genetic tests give you information that doesn't have to be the same as knowledge. And to illustrate this, I would simply note that when you hear that a group of people was tested for BRCA1 alleles, and that people with a given allele have an elevated risk of breast cancer, you need to remember that's a statistic taken from a sample. And its translatability to any one person as an individual can be very limited. So whether it's a homebrew test or whatever, there's a simple validity to, whatever you learn from the test. Can you really conclude anything from it? Or as we often make the point, and Craig Venter made this last night, human biology, whether we have 26,000 genes or 33,000 genes, is enormously complex. And just one genetic test result is probably not going to have that much informative value.
Bob?
Searching for a question that might unify the rather disparate themes here, and I think there is one area that might be interesting to get your first reactions to. One of the areas of genomics that is in the private sector for the most part is pharmacogenomics testing. A lot of the genotyping is it's happening in connection with clinical trials of large populations. It's kind of it's not the central theme. You're doing a clinical trial, you get a blood sample, and then you do genotyping to see if it's going to help you. Huge databases being created on tens of thousands of people, much bigger generally than what we're talking about in the public domain,
Right.
that we usually think about. But we have this problem that we're generating lots of information that actually might be very relevant to a lot of people, including other drug companies, but also the world in general. And how are we going to get that information into a forum that is useful to everybody, given the way things usually go with that kind of research? Has there been any discussion about how to handle this kind of collective action problem?
I mean, there's been discussion that's identified the problem, but I don't know of any serious policy proposals. I mean, you're right, the proportion of samples that are privately held is just going up and going to go up because of pharmacogenetics and because of who's doing pharmacogenetics. And there could be tremendous inefficiencies. I mean, if there are these large sample collections in private hands, and say CDC doesn't have any access to them for some particular reasons that it might want and has to go out and collect that many samples again, it's prohibitively expensive, extremely inefficient.
Well, this is the crux of the problem that Dr. Drell and his boss, Ari Petrinos, are involved in. And I was recently a guest at another conference at the academies where the leading lights of the scientific establishment all got up there and went through a sort of bizarre staged routine to reaffirm their undying and absolute adherence to open access, uber alles, and without any exception. And two things happened in that. Two or three people from industry came up to tell me this is crazy, they'll only get less data, and I got up and said that, and I said, you're totally ignoring the database, right? And then Petrinos got up there, and to his everlasting credit, just lambasted them and said, this is really disgusting in a way, because you're up here, the leading lights of science, discussing issues about which you absolutely know nothing and have taken no steps to be informed. So in addressing this problem, you're going to have to address and deal with this sort of unlimited bias that the pure, unconditional deposit of data is the only way. And it isn't going to work in the private sector. Now, I'm assuming that with regard to these clinical databases, there's no government-funded data there. I mean, one of the points we make in our study is where the government is funding the data, then there is a shirking of responsibility if there are not some contractual templates that go along with it. What uses are going to be made from this? But here, this is perfectly privately funded data, and there we ought to be in the position, as Drell and Petrinos rightly say, of incenting them, of giving them every possible reason to make this available for their own benefit. And there are a lot of very interesting new developments. The people who developed this, I think Singen, is very strong on public access to the data that we're using. They benefited from it. There are a lot of industries at the forefront of research in these areas that understand the importance of it, but we have to come up with some contractual templates that we can all live with and not just say, oh, poo-poo, we can't go that route because it's not 100% public domain approach. There's a conditional deposit. So I think there's a mentality step there that they have approached very delicately. We maybe will approach a little less delicately, but it's going to have to get overcome.
I rather doubt there's going to be a one-size-fits-all approach to this. I mean, there clearly is genomic sequence information which, the Court of Appeals for the Federal Circuit notwithstanding, most of us, I think, are comfortable viewing as information, not tangible products. And then there is the database of clinical samples that is, I think, qualitatively different and raises qualitatively different issues. I have quietly in a few venues tried to suggest that yet another study, it would be nice if someone did, perhaps a Atlantic Coast State University with access to a nice big hospital. It would be very interesting to take a medical data repository / database containing a great deal of personal information and ask, what would you need to do to sufficiently anonymize it so that you'd get around some of these challenges? Is it?
Yeah, absolutely.
I'm glad to hear that. I mean, I'd be very interested to know how it turns out.
It's done by private entities too. I mean,
Okay.
they use a double coding system at GlaxoSmithKline, for example. Lots
Who has access then after they do that?
Well, it doesn't solve the problem that Bob raised, but it's the first step. It puts up a firewall between the particular researcher and the participants, but it doesn't tell you how you get the information out of that closed system to other.
It'd be interesting to know then if the protocols used at Glaxo have portability to other people with similar kinds of databases.
That's just the issue. I think what you've got is just a huge patchwork with people reinventing the wheel in complete ignorance of what's going on right next door. In fact, I would suppose that at many university campuses you have a number of different collections with different rules for informed consent, different coding procedures, and that they're missing out on efficiencies within their own campus system that they could have if they had a pooled, standardized kind of approach.
Yes. Yes.
Oh, me?
No, actually, the gentleman in front of you, and then Artie, you can go next. Sorry.
I'm curious, Dr. Newmark, when you characterize the disadvantages or drawbacks of researchers placing their data in public databases when it's been or it's subject to patent protection as a danger, because they don't know who might be using it and they can't really enforce. I would characterize that as almost a de facto research exemption, in that if people are free to use that information, maybe in secret, if they use it in secret to conduct screens or research, and it turns out to be not fruitful at all, then it falls by the wayside. Whereas if it does turn out to be a good research lead, then they end up having to come to face with those intellectual property rights. And I didn't know if there's any way to institutionalize that as sort of is there a way to encourage that activity through the journals, or perhaps you made this point and I missed it in your talk.
I take a very simple view that the journals ought to keep out of this. It's very, journal publishing is a different business from trying to control what happens afterwards or worrying about the legal implications. I just think it's probably a fact that that if you have some information that you want to keep control over. It's easier if you keep it in your own territory than to put it in a generally accessible one. I don't know if that's true, and something that I'm sort of curious about listening to Dan here and related to that in a way is we don't want secrecy. Obviously, anything that will help get data out is good for everyone. The question really is there any evidence that the current conventions to which have been devised and to which journals tend to force people to adhere, whether that actually is a disincentive? I mean, I think there's a lot of reasons for trying to find incentives, but I'm not sure if the current system is a strong disincentive. If one had databases where there was a 6-month hold on access and so on, is that really going to make the difference? I'm not convinced that this data is, there are people pressing to publish it, and that's what's holding it up.
My only reaction would be